we can kind of cross that bridge when we get to it.
Okay.
And I think, we can push forward. It's 2:30 now. I tell you, the state intends to call Agent Bigham next.
Okay.
Which I imagine Mr. Cruz would have a fairly lengthy cross-examination for, just based on some of the prior hearings and stuff. So if that doesn't get us to a latter part of the afternoon, we could call Agent Howell, who has some testimony about crime scene and other related things. But I would ask the court that before I got to the point of talking to him about the statement and putting it into evidence, if we could break for the day at that point, just so, or just not start him, honestly, might be. But however the court wants to handle it, we'll take your direction. But I will say a little more time to make sure I have the redactions exactly right would be helpful.
All right, thank you. Yes, sir.
And I would just ask out of abundance of caution, and Mr. Yalamachili may already be about to do this, but if not, our office could cut off the video. We actually take parts out of the video, if you all would like, and give a copy of the video that will play through, but only with the relevant portion.
I'll let you all work on that. I don't think I need to get involved. I don't think I need to get involved in that. I'll let you all talk about it. I think it is fair to say that we do need to take a break before you wanted to introduce the video. We'll do that whether it's the end of the day or tomorrow morning. Just for the record, to be clear, the motion is granted. It has always been granted. I think the issue was to get both parties on the same page if possible, and then if not, I'd hear both arguments about what is admissible and what's not. But as long as both of you have agreed that the portions that are going to, as long as you both have agreed to the portions that are going to be redacted, I'm not going to get involved in all of that. That's fine. I will grant your motion with the basically stipulated moment that you both have come to about what needs to not be entered into evidence. So if we need to take anything up, if it becomes clear that maybe you don't have a meeting of the minds, you need to let me know as soon as possible so that we don't, the jury doesn't hear it. But other than that.
Yes, Judge.
All right.
That's the plan. I think so. Thursday at the latest. Today's Tuesday.
I will. Yeah.
Thursday at the latest, but I would anticipate.
Field has asked to remind you, if you can, to wear the lanyard as best you can, or use the microphone so she can hear you.
Yes, ma'am.
Thank you very much. And if Mr. Yalamachili has that issue, we're going to find one for you too. So.
Yes, ma'am.
She just needs to hear you, that's all.
Yes, ma'am.
All right. Anything else, Mr. Cruz?
I know that the court talked about this morning in regards to the link. One of the witnesses, they're out of the country, so I just want to make sure that I can sync it up with them before the state rests. And I understand the state may be resting at earliest tomorrow, at latest Thursday morning.
Oh, you mean for the WebEx?
Correct.
Sure. So when you all seem to have a better idea of when that person needs to be called, we'll take it up and we will figure out the best time. If this person is out of the country, we're also, I guess, dealing with a time change.
Right.
So we'll work it out. We'll make it happen. It's not terribly complicated, but it does require some advance preparation to be able to make it happen.
Yes, ma'am. And just to let the court know, I would have to give her advance notice because I think when we're here and it's daytime, for her, I think
Right. I mean, that's what I mean. Yes, I understand that completely, but I think it's just best to get a little bit better time frame.
Yes, ma'am.
Because if you give a time frame now and that's not going to be the time frame, it's hard to change it. You'd have to sort of cancel it and do it all over again, and that might be more complicated. So, but we'll make it happen. I think the one thing to tell all your witnesses, whoever is going to be on WebEx, and I don't think the state has made a proffer that any of theirs are going to be on WebEx. Obviously, it's the defense's ability to object to that. But WebEx is the medium, and so, or the mode, or whatever you call it. And so your witness is going to have that downloaded on whatever apparatus your witness is going to use, whether it's a phone or a computer. WebEx is the only medium the courthouse can use.
Yes,
so, all right. Anything else, sir, before we bring jury up?
No, ma'am.
All right, thank you. Mr. Yalamanchili, Ms. Rowland, anything else?
No, Judge.
All right, thank you. Mr. Chair, if you'll bring the jury out, thank you. On the record, State of Georgia versus Edrick Faust, SU 24 CR 0547. State ready to proceed?
State's ready, Judge.
Defense ready?
Yes, ma'am.
All right, thank you. Mr. Yalamanchili, you may call your next witness.
State calls Agent Elizabeth Bigham.
Your Honor, before you start answering,
Yes, absolutely.
Your Honor, we need to take up a matter outside the jury that Ms. Bigham is being called before she testifies.
All right. Ladies and gentlemen, I know you just got here. I'm going to take up something outside your presence I was not aware of. If you'll have a seat and don't discuss the case. We had done this before the jury came out, Mr. Cruz, but go ahead.
And I apologize, Your Honor. I was under the belief that Jeremy Howell was going to testify, and that's why I didn't bring it up. I was going to wait till Ms. Bigham testified before I brought it up. But we're going to get into, with Ms. Bigham, her case file and the case file. As the court is aware, during a prior hearing, Ms. Bigham testified that she's seen every document in this case. One of the documents that we're going to discuss with Ms. Bigham includes where Mr. Faust was staying at the time of, or at least the weekend of Ms. Baker's death. I would ask the Honorable Court, because the only thing we're going to get into is just the address and where he was staying. However, it goes into a matter that the state has expressed that they don't intend to introduce in this case. And I would like the Honorable Court to provide an instruction to Ms. Bigham not to delve into the incident or the specifics of the incident involving Mr. Faust and Mr. Christian Foster. And we will not open that door by asking specific questions about the situation with Mr. Faust and Mr. Foster. We only intend to discuss Mr. Faust's address on the weekend of Ms. Baker, and before Ms. Baker's death.
All right, so it's motion in limine.
Yes, ma'am.
All right, any response to the motion?
I guess I would like to know what the document is first that Mr. Cruz is making reference to.
Didn't we also already have a motion in limine with regard to Mr. Foster?
We did not have a hearing on this. The state stated that they did not intend to call Mr. Foster.
Okay, so we've had a discussion. Okay, okay.
Picture. I don't want it to fall on. Picture looks like it's about to fall.
Your Honor, it appears from a preliminary review of this document that what Mr. Cruz is referring to is a statement from one of the witnesses of the incident where Mr. Faust stabbed Mr. Foster, who states to law enforcement that she used to date the suspect for approximately a year. He lived with her for some of that time, and she additionally said that the suspect stays with his girlfriend, Brenda Howard, in Knollwood Apartments off of Old Hull Road. So, one, I don't think any of that is admissible. It is double hearsay. It is a statement by a witness to a separate law enforcement officer that is then memorialized in this report, and that'd be Detective Sean Potter, who I think is deceased, Judge. And so the state is not planning to elicit any statements regarding what was told to Detective Potter from Agent Bigham. And I don't believe that Mr. Cruz would be allowed to do so without it drawing a hearsay objection, which the state would make, and therefore I'm making an oral motion in limine to ask that Mr. Cruz not be allowed to elicit double hearsay information without the state having opened the door to the same.
Mr. Cruz?
Thank you, Your Honor. The statement is not hearsay. Ms. Bigham is the lead investigator. The state's position for this entire case has been that Mr. Faust stayed at 350 Cooper Road. As the lead investigator, the fact that Mr. Faust actually stayed in Knollwood Apartments goes to information that she knew, and that's the objective effect. As the lead detective, she was aware that Mr. Faust, or at least she had information in her case file, that Mr. Faust did not stay at 350 Cooper Road. The state presented same in their opening, despite Ms. Bigham being in the courtroom with the state and having knowledge of this situation. So it's not hearsay. We're not offering it solely for the truth of the matter asserted. We're offering this information to show this is information that Ms. Bigham had. This is solely entered for its objective effect, so it is not hearsay. So, and the simple way is to, she knew this fact. She was aware of this fact. That's the sole purpose of it.
Okay, well, I guess let me start with this.
Sure.
First of all, that doesn't get around the hearsay problem, even offering it as something that tends to show an objective effect or for the purpose of showing what's in a case file does not overcome a hearsay objection. So I want to get that straight. I guess what I don't understand is what are you trying to do with this piece of evidence? Maybe we should start with that. Are you trying to tender that or question Agent Bigham about what's in that document or something different?
So I would only, and I will follow the Honorable Court's ruling. I always have, I always will. I disagree with the interpretation of the law. I would like to provide the Honorable Court with some law in regards to non-hearsay, not hearsay, and hearsay. This will fall under, if I understand correctly, non-hearsay because it's offered solely for its subjective effect and knowledge that Agent Bigham knew. But as far as my intention with that evidence, it's just simply to ask her, same thing we've already discussed. You've reviewed the entire case file in this case. Mm-hmm. And based on your review of that case file, you're aware of information that Mr. Faust resided at Knollwood Apartments at least as far as the weekend of Ms. Baker's death. That's as far as I would go with that line of questioning, Your Honor. And may I provide the Honorable Court with case law in regards to objective effect?
You may, but let me just ask the state what the question you have just made. Mr. Yalman-Shilley, based on that question that Mr. Cruz has proffered, I realize there are objections the state is making kind of surrounding what that question may elicit. But in terms of the question itself, does the state have an objection about that particular question?
Can I get the question one more time, Your Honor?
Mr. Cruz, if you don't mind proffering again for the court the question you said you were intending to ask.
Sure. So the first question would be, Ms. Bigham, you reviewed your entire case file. And based on your review of the case file, you are aware of information in your case file that Mr. Faust resided in Knollwood Apartments or at Knollwood Apartments around the time of Ms. Baker's death.
Okay. With regard to that question, Mr. Alamichile, I realize you may have some comments about, again, what you're saying the defense is trying to elicit. But in terms of the question itself, do you have an objection to the question?
I think that I do not have an objection to the question if it is phrased as you were aware that Mr. Faust lived at Knollwood Apartments.
Right.
I think once you make reference to information within the case file, you're getting to a point at which the question is referencing this hearsay information or double hearsay information that Mr. Cruz has just identified in this police report. I think he can ask Agent Bigham that question, and then she will answer it in whatever way she does.
I mean, I wanted to give you an opportunity to respond, but that would certainly be my sort of first response to you, Mr. Cruz, is that is not an objectionable question. I think the question becomes what happens with the answer. And so since we're talking about this document that you've just given to the state, can you proffer what might come next? Because we need to talk about whether the information in that document is going to be admissible.
Sure. Agent Bigham would be under oath, so I anticipate Agent Bigham, not even anticipate, I trust as an officer of the law she would be honest. So I couldn't imagine her saying no. The state would have obligation as well if Agent Bigham was to be dishonest under oath, and I don't even want to imagine that because I don't think that'll happen. But I expect that once I asked the question in regards to the information she had that Mr. Faust stayed in Knollwood Apartments around the time of Ms. Baker's death, I just anticipate that being a yes and us moving on.
Okay.
Well, and Judge, if I could
Sure.
briefly, just, I mean, anyway, I don't know what Agent Bigham's answer will be. I would like to state whatever her answer is. I don't agree that one answer or the other could be characterized as a dishonest answer when we're talking about the source of the information being a double hearsay statement from a witness that, from my memory out of the case file, the GBI never directly talked to in kind of a collateral matter involving Mr. Faust, or an other acts matter at the minimum.
Okay.
And I have a case for you, Your Honor.
Case for the court for what?
In regards to this information being non-hearsay.
All right. If you want to give me the case, but explain to the court why it is not hearsay. I mean, you've stated that it is, I'm assuming what you meant, but tell me if I'm wrong, that you're saying that it is not hearsay because it doesn't go to the truth of the matter asserted. Is that what you're saying?
It goes to notice.
All right. All right. Whatever you would like to provide the court, you certainly can.
It's a 2025 case. It's Vaughn v. Winfield, Homeowners Association, Inc., 375, Georgia Appeal, 18, 913, Southeast 2nd, 74. And as an example in this case, it states, disclosure at the time of, and this is the facts of this specific case, but showing how it was non-hearsay. Disclosure at time of sale that Homeowners Association was mandatory was not hearsay offered for its truth, but offered to show buyers had notice of the legal status of the association. The next case is U.S. v. Schley. That's SCHLEI. That's 122, capital F, period, 3D, 944. This is page 981. And it states, statement offered for the effect it would have on the hearer, providing knowledge that certain instruments were forgeries is non-hearsay. Also, Benford, and this is the last case I give on the court. I have a list of them, but this is the last two cases I give on the court. Benford, Benford, v. Richards Medical Co., 792, capital F, period 2D, 1537, page 1540. Non-hearsay when it's shown or entered to establish the effect on the hearer. In that particular case, it was to prove notice of problems. In our case, it's to prove notice of Mr. Faust's address at the time of Miss Baker's passing. And the final case is U.S. v. Darby. That's D-A-R-B-Y. That's 744, capital F, period 2D, 1508, page 1524. And non-hearsay when introduced to show effect on the hearer. In that case, to intimidate witnesses. In this case, to show notice of Mr. Faust's address at the time of Miss Baker's death, Your Honor.
Okay, so let me ask you this question, Ms. Cruz. I want to make sure I understand what you're asking
Yes, ma'am.
to have permission to elicit. Are you asking for permission through that document to elicit information through, as the state has called it, double hearsay, to present evidence of Mr. Faust's address at the time of the incident?
And
you're calling that notice. Is that right?
No. Let
right.
me make sure I understand your question. Are you asking me if I'm attempting to introduce the document?
No.
Okay.
What I'm asking you is, I want to make sure I understand what you're trying to do. Are you asking to receive permission that the information in the document you gave the state, that the state refers to as double hearsay, about Mr. Faust's address? I'm assuming that, is that right? That's what you're saying is double hearsay is the address? Or the people that said what the address was?
That's right. So
Okay.
there's an individual, a witness,
Right.
who says she knows that or believes that Miss Brenda Howard lives at Knollwood Apartments and that Mr. Faust stays with her, and that is relayed to Detective Potter, who then puts it in the police report.
Okay, thank you. And Mr. Cruz, tell me if this is right.
Sure.
That you are asking permission to introduce or elicit testimony about that, what Mr. Yellman-Shirley just said, because under the notion that that information is simply notice to the hearer of where someone lived.
The reader. In this case, it would be the individual reading the document, but correct.
And so you're saying that's just simply notice?
It's non-hearsay because it's notice of Mr. Faust's address at the time of Mrs. Baker's death. Correct. It's just notice. She had notice of that information.
Okay. All right. Thank you for that clarification.
Yes, ma'am.
Mr. Yellman-Shirley, anything further that you would like to argue?
Not anything
Okay,
further, Judge.
that's not notice. That is a fact that if the defense wants to raise and properly get admitted and properly present evidence supporting that, the defense is able to do that. But that's not notice. That is not the effect upon the hearer. That is a material piece of information or evidence that needs to be proven, as every other piece of evidence in the court of law needs to be proven. And so it is double hearsay. It is not just notice. And I'm not going to allow it, Mr. Cruz, in the form that you're asking to introduce it. I'm not prohibiting that information if you choose to present it in a way that is supported by the law, but not in this manner, not by double hearsay.
Yes, ma'am.
All right, thank you. All right, anything else?
Nothing from the state, Judge.
All right, Mr. Cruz, anything else, sir?
No, ma'am.
All right, you may bring the jury out. Thank you. Wait, hang on one second. Did you need to say something, Mr. Hill? Who wanted to get my attention? I'm
I
sorry.
was going to ask you this.
Yes, hang on a second, sir. Yes.
It's multiple ways I could ask that question, Your Honor. I just want to make sure I don't run afoul of the court's
Okay.
order. So if the court can make clear on the record exactly what I am prohibited from asking, it'll help me make sure I don't offend the court in any way or fail to abide by the honorable court's order.
Well, I mean, I would say that is a difficult thing to answer in that context. the order says that, the order that I just said orally says that you cannot elicit the information you are asking to elicit in the method that you are asking, for example, by means of double hearsay. And so I don't know if I can be any clearer than that. Double hearsay, unless there is an exception to that, is not allowed.
So I won't ask her about a statement. Is it okay if I ask her if she's aware of information that Mr. Faust did not reside at 350 Cooper Road
Right.
during the weekend of Ms. Baker's death?
Before I answer that, I'm going to give the state the opportunity to respond, since we're sort of in this context of proffering and things of that nature. Mr. Yalamanchili, anything you would like to say in response to that query?
Well, I think that the information that he's making reference to is still the double hearsay, Your Honor. So I think it's the same analysis with some semantic changes.
All right. Mr. Cruz, anything further, sir, that you would like to ask the court?
I would just say that doesn't, my position is it doesn't fall under hearsay, but I respect the Honorable Court's ruling, whatever it may be.
Well, let me ask you this question. The document that you have provided that we're talking about, is that the document that you're claiming gives this agent the information that you're seeking to ask her about?
Correct.
Okay, then I would say that it is barred. I would, just based on my prior ruling. So I would say you can't ask that question.
Yes, ma'am.
All right. Anything else, sir?
No, ma'am.
All right, thank you. You can bring the jury up.
Motion. I have a motion. I have a motion.
All right, you want to do it at the bench, or?
I need to do it outside the presence of the jury.
You do?
I do.
All right. Go back to the jury room. Don't talk about the case. Y'all may be seated. Yes, sir.
I'm moving for a mistrial. The state, throughout this case, in opening, they stated that Mr. Faust stayed at 350 Cooper Road. That information is false, it is not true, and it's shown by their own report. Before this trial started, we had Agent Bigham on the stand, and I specifically asked Ms. Bigham, Ms. Bigham, have you reviewed your entire case file? Ms. Bigham said, yes, I reviewed my entire case file. As of right now, Mr. Faust cannot argue consent. Mr. Faust's counsel has been held in contempt due to an interpretation of the rape shield statute that, of course, I disagree with, but I follow the Honorable Court's rulings. But now we're being told not only can't argue a material defense to rape, we're also being told, despite the fact that the state knows that Mr. Faust did not stay at 350 Cooper Road, they are still able to present, please forgive me, Your Honor, I'm talking too fast, but present this false information. And we're being told that we can't confront that information, we can't cross-examine that information, because it falls under hearsay, although it's offered solely to show the fact that the state had notice. Mr. Faust can't defend himself, Your Honor. If we know that the state is presenting evidence that is not true, we should have opportunity to rebut that evidence through this agent. This agent, I anticipate, will testify that Mr. Faust stays at 350 Cooper Road, and he did not. So we don't believe Mr. Faust will get a fair trial. We do believe that ruling is extremely prejudicial because the jury would only be presented with not even only, they would be presented with information that's not true, Your Honor. So we would ask that the Honorable Court grant our motion for a mistrial, Your Honor.
Thank you, Mr. Cruz. Mr. Yalamichili, do you want to respond?
I don't think I need to, Judge.
All right, thank you. Mr. Cruz, I would ask that when we have a recess, you look up the law on what a mistrial actually is and the grounds for it. This is not one of those. The comments that you make do not satisfy the requirements for the court to consider granting a mistrial, so I'm going to deny your motion. I want to respond to a few things that you have said. The prohibition that you have referred to for the courts not allowing what you have referred to as a material defense to a rape allegation is a lot more complicated than the manner in which you have described it. We've talked about the defense's failure to file the appropriate motions that would enable the court to hear whether the information, defenses, or evidence you seek to introduce would actually be admissible. And so that's something we've gone over many, many times, and I know that you know that. And so it isn't simply a blanket decision by the court to not allow certain things, but it is a response to whether the evidentiary and procedural rules have been followed, and I found they had not been. So that's the first thing. With respect to your other arguments, Mr. Cruz, they are best handled by appellate courts. They are not grounds for a mistrial. You will have every opportunity to cross-examine this witness. You will have every opportunity to cross-examine every other witness that you disagree with. But the complaints that you are lodging are not mistrial moments. They are moments for other courts to review. And so I'm going to deny your motion at this time, and I'm going to bring the jury out, and we're going to get started, unless there's something else we need to talk about. Anything else, Mr. Cruz?
No, Your Honor.
All right, thank you. Mr. Yalamichili, anything else?
Nothing from the
All right, very
state,
good. Can you
Judge.
bring the jury in? Thank you. We're back on the record. Mr. Yalamichili, you may call your next witness.
Thank you, Judge. The state calls Agent Elizabeth Bigham, who has already taken the stand. Ms. Bigham, will you raise your right hand and take an oath? Do you swear or affirm the testimony you'll give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
If you would, please state and spell your name for the record.
My name is Elizabeth Bigham, Elizabeth Bigham.
Where are you currently employed, ma'am?
I'm employed as a special agent with the Georgia Bureau of Investigation, and I'm currently assigned to our Office of Special Investigations Cold Case Unit.
Prior to that assignment, where did you work in the GBI?
So prior to this, I spent about 10 and a half years, or maybe just under 10 and a half years, at our Child Exploitation and Computer Crimes Unit, where I worked cases involving the online exploitation of children, child sex trafficking, and child pornography cases. And then prior to that, I was assigned to our Athens field office for about 6.5 years. And I worked general investigations to include anything from homicides to aggravated assaults, thefts, child molestations, etc.
Before you worked for the GBI, did you have any other kind of law enforcement experience?
No, I did not.
Okay. And when you become a GBI agent, what is the training process to become an agent?
So it's changed over the years, but back when I went through the academy in 2007, it was a 14-week basic GBI academy where we did everything from learning law to learning how to write search warrants, emergency vehicle operations, shooting, etc. And then after that, we did a 2-week undercover narcotics school, and then we were sent to our respective field office, and we were involved in a field training program. I don't remember how long it was. It varies because there's basically a field training book, and you have to check off certain things. There's so many interviews you have to do. You have to fingerprint someone. You have to do all these different things. So it can vary in how long it takes. But I would say on average about 6 months or so, and then you're kind of on your own with the help of older agents or more seasoned agents.
As it relates specifically to the Office of Special Investigations, as well as your unit, the cold case unit, when is it and how is it that that unit came into existence?
So our unit was established as part of the Coleman-Baker Act. Our unit was established in July of 2023, and there are 10 special agents that are assigned to that office, and we essentially work cold cases. That's our primary responsibility. And the Coleman-Baker Act was enacted, I don't recall the specific date that it was enacted prior to that, but essentially there's some criteria that you have to meet in order to file a Coleman-Baker application. And those are that the case had to have been a homicide.
Mr. Yalman-Chile, do you care to respond to the objection?
Your Honor, it goes back to this witness's training and experience.
Yes, sir. Okay, I'm going to overrule the objection. You may continue.
And Agent Begum, I think you had just started in on talking about some of the statutory criteria for making a request.
Yes. So the case had to have been a homicide, had to have occurred after 1970. It has to be at least 3 years old, for lack of a better word, or cold if you want to call it that. There are some criteria that indicates that it has to be, or it has to have been investigated by a GBI office if you're requesting the GBI, but also you can request the police department or sheriff's office that was the initial investigating agency under the same thing. And that the leads and all of the kind of probative leads have been exhausted and there are really no suspects at that point. And that's kind of the criteria that you have to meet. I believe you have to be a family member as well of the deceased.
When is it that you joined the unit?
I joined October of 23.
And did you, at any point after you joined the unit, were you assigned to review the case of the murder of Tara Baker?
I was.
Okay. Do you recall approximately when it was when you were assigned that case for investigation as part of the cold case unit?
If I'm not mistaken, it was the first case I was assigned.
All right.
When I got there.
And was there any other agent who was assigned to that case as well with you?
Yes. Special Agent Jeremy Howell.
Once you received that assignment, and kind of more generally, once you receive a cold case assignment, what are the initial steps that you take and took in this case?
So I don't know that there's a specific way you have to work a cold case every single time. I think it's kind of our preference as well, our agent preference, how you're going to start and what you're going to do. But logically, you'd get the case file and start reviewing the case file. In this particular investigation, it was a bit unique in the sense that Athens Clark County Police Department had an extremely large case file, and GBI also had an extremely large case file. So it took a minute to collect all the files, get all the Athens stuff, get all the GBI stuff together, and kind of mesh it all together to figure out where we were at and where we needed to start.
And you mentioned an extremely large case file for ACCPD and an extremely large case file for the GBI. How did the volume of this case file compare to other cases you had worked as either an agent dealing with the sexual exploitation crimes that you made reference to, or prior to that when you were an agent working homicides, aggravated assaults, et cetera?
Mr. Young, would you like to respond to the objection of relevance?
I think it goes directly to the amount of information that Agent Bigham had to review and digest as part of her work on this investigation.
I'm going to overrule the objection. You may continue.
So our GBI case files, before we went electronic years ago when we used to print everything, they're generally about an inch thick, and if I'm not mistaken, there's 25 or 27 of those at the GBI office in Athens. So there's about 27 volumes. We called them a volume, and they were generally about an inch thick. And then the Athens file, if I'm not mistaken, was about 15 4 or 5 inch thick binders of just paper and printouts and things of that nature. And then there were also multiple boxes containing various pieces of the case file, and we kind of had to get it organized a little bit.
And that's just the paper associated with the case, is that correct?
Yes, I would say it was about 20,000 pages or so.
Is it important to review the physical evidence in the case as well?
Oh, absolutely.
Okay. And so is that something that you did as part of reviewing the case file in this case?
Yes. Agent Howell and I, in December of 23, spent a few days over at the Athens Clark County Police Department going through every single piece of evidence that they made available to us, which was, my understanding, was everything but one piece, which stayed in the evidence room but was accounted for. And we inventoried it, created a spreadsheet to help us follow it, because the Athens evidence had been through, I believe, 3 iterations of an evidence program. So we wanted to ensure that, you know, the barcode it was given when it was first taken in 2001 matched up to what barcode it had now, and it all kind of stayed consistent. We wanted to see if we had any missing evidence. We wanted to see if there was anything that was unaccounted for. So we spent days just going through every piece one by one, documenting it and ensuring that it was present and where it had been and things like that.
That talks about physical evidence in general. I want to talk to you a little bit now about a subset of physical evidence that I'm going to refer to as biological evidence, okay? As a cold case unit investigator, what importance does biological evidence have to you and to your job in investigating cold cases?
So I think that's kind of what we were focusing on initially, because those are the things that we can send back to the crime lab and hope that there's potentially updated testing or new testing, and at that point it would have been, 23 years or so, that we can maybe get something from. So we obviously noted things that could potentially be retested or tested with new technology that was available.
So you used the phrase 23 years or so, and I mean, I just want to make sure that we're clear about what are you referring to, 23 years from what?
2001.
Okay.
January 19th of 2001.
All right. And so is that a process you went through in evaluating the physical, biological evidence in this case?
Yes, Agent Howell and I documented everything, and eventually we had a meeting with our crime laboratory about that.
Okay. And I don't want you to get into anything anybody said during that meeting, but based on that meeting, did you make a determination about resubmitting certain items of physical evidence?
We did.
Okay. And let me ask this also. Are these things happening one after another sequentially or all at the same time?
It's kind of all at the same time. Well, in December, we're inventorying evidence, and then we're still reviewing the file. And then in, February, we have a meeting with the crime lab. We're still reviewing the file. We're just kind of doing different investigative acts, but all sort of at the same time. And once we do one thing and it's kind of holding for a minute, we move on to some other things.
And as it relates to, besides review, particular steps that you take, as part of your review, do you kind of create an idea of who the witnesses were at the time of the actual crime?
Yes. As we were reviewing the file, we would make notes about maybe potential people we wanted to re-interview just after sort of an initial review of everything or reading it through the first time, and start just kind of keeping notes on what we wanted to do separately from the evidence.
And so as part of y'all's investigative actions in this case, were certain witnesses re-interviewed?
Yes.
Okay. Did you yourself conduct all of those interviews?
No.
Okay. Besides you and Agent Howell, was there anyone else from the GBI who was kind of helping with some of those interviews as well?
Yes. Many of the other agents from our office, and then also some agents from field offices around the state. So for instance, if we had an interview in South Georgia that was 4 hours away, I would ask an agent to handle that for me.
At any point, did the resubmission of some of that biological physical evidence from January 19th of 2001 yield any new information?
It did.
Okay. And what information is it that you received?
So on April 30th of 2024, we received, and by we I mean Agent Howell and I, received a crime lab report in reference to some DNA evidence. Okay.
Okay. So I'm sorry.
All right.
That's all right. And you did the right thing. And so I just want to take you back to the question there for a second. And it was, what information did y'all receive?
Okay. So as part of that crime lab report, we learned that there was a match to DNA in the sexual assault kit that was taken from Tara Baker at the time of her autopsy.
Okay. And when you say a match, was there a particular individual or individuals to whom that match came back?
Yes. It came back to Edrick Faust as part of the oral swabs that were tested out of her sexual assault kit.
Okay. And when you're saying oral swabs, you're talking about swabs labeled as oral swabs.
Yes.
Is that correct?
Yes.
Okay. And was there any other individual to whom a DNA result came back?
Yes. There were additional reports that were issued as well within a very short time period. But we also were informed that there was DNA matching Christopher Melton as well from different parts of the sexual assault kit.
And so I think you already testified this would have been April 30th of 2024. Is that correct?
Yes, when the first match report came out.
What investigative steps did yourself, Agent Howell, or other law enforcement involved in the investigation take at that point?
So after we received Mr. Faust's information, and then subsequently, a few days later, when we received Mr. Melton's information, we obviously knew who Mr. Melton was and started to conduct some interviews. We went and re-interviewed Ms. Hall, or Ms. Peavy, Ashley Peavy, Tara's roommate, went and re-interviewed Ms. Lowe, or Dr. Lowe, Valerie, and started to just kind of go over everything that we had, read in previous interviews through the case file. We looked at the case file again as far as Mr. Faust was concerned to see if his name had ever come up or if there was any reference to anything like that, and we did not see anything relating to him in the case file. So we started to try and kind of familiarize ourselves with Mr. Faust and who he was. We conducted, like I said, some additional interviews and essentially kind of went on from there.
Okay. Did you ever re-interview Mr. Chris Melton?
We did. We interviewed him on a Sunday morning, I believe it was May 5th.
Okay. In your review of the case file, did you find any information connecting Mr. Faust to Miss Tara Baker?
The only information, no, we could not find any connection between Ms. Baker and Mr. Faust, except that Mr. Faust lived 585 feet from Ms. Baker's residence.
Okay, and what address is that you had that was 585 feet from Ms. Baker's residence?
350 Cooper Road, Athens, Georgia.
Based on what you did up to that point, did y'all make a decision on whether or not to arrest Mr. Faust?
We did.
Okay. And when is it that the arrest was executed?
May 9th, 2024, so about 10 days after we received that report.
Okay. Following your arrest of Mr. Faust, did y'all continue your investigation of this case?
We did.
Okay. I want to talk to you a little bit about your understanding of the DNA evidence back on April 30th of 2024 and in those subsequent couple of weeks. At that point, what was your understanding of the DNA evidence?
Your Honor, based on the court's prior ruling, that would constitute hearsay. So we have a hearsay objection.
All right, Mr. Yellow-Chili, any response to the hearsay objection?
Your Honor, I think asking her understanding of it is not hearsay.
Go ahead, sir.
We had a hearing outside the presence of the jury in regards to the exact same thing. Potentially so that our question is hearsay, that question is hearsay.
I'm not quite understanding your objection, so I'm going to ask either both. Why don't you both come to the bench for now? If we have to send the jury out, we will, but let's start at the bench.
Agent Bigman, I'm going to ask my question in a different way, ma'am. When you reviewed the physical evidence in this case, did you identify any swabbings that were labeled any kind of way on the exterior of the envelopes?
Yes.
Okay. In your review of the autopsy and your review of those envelopes, what were the labelings on the envelopes that you reviewed in the physical evidence as related to the swabbings from the sexual assault kit done at the autopsy?
Right. So our understanding was that there were 2 packets of swabs that were labeled oral swabs and 1 that was labeled rectal.
Okay. Did that seem to, I'm trying to find the right word for this, make sense when taken in conjunction with the autopsy?
No.
Okay. What about it didn't make sense?
Well, the fact that they took or that 2 packs of oral swabs were taken, 1 of rectal, but no vaginal swabs were taken, seemed kind of odd. And we knew from reviewing prior crime lab reports that we had vaginal smears that were made back in, I believe, 2001. So obviously, if a vaginal smear was made, a vaginal swab had to have been taken. So our understanding at that point, and from what we learned from the crime lab as well, was that there was something was amiss as far as what got labeled incorrectly.
Is this something that you discussed with the GBI crime lab?
Yes, we did.
After discussing it with the GBI crime lab, did you make a decision about any other labs or testing that should be pursued in this case?
Yes, after consulting with the crime lab, we learned about Pure Gold Forensics and that they were a company that could help us to potentially differentiate between the swabs
And
scientifically.
When you say differentiate between the swabs scientifically, which swabs in particular are you making reference to?
2I and 2J, or 2I is oral swabs B, or swabbings B, I think it says, and then 2J is swabbings A.
Okay, so the two things are both labeled oral swabs?
Yes.
Okay. And what steps did you take to facilitate Pure Gold's review of those 2 pieces of physical evidence?
So we had a video conference with, I believe he's the owner or CEO of Pure Gold, I'm not really sure of his title, and explained a bit about the case and what we had going on and what we were looking for, and asked if that was a possibility, if that's something their lab could do. Obviously, we received a quote for how much that was going to cost, and I ended up sending off the cuttings of swabs that were provided to me by our crime lab to Pure Gold for testing.
And now, just to put some dates on these things, when is it that y'all sought help from Pure Gold in order to make a determination about what was actually in each of the oral swabbing labeled envelopes?
I honestly don't remember when we had that video conference. I don't remember.
Do you remember when you received the results from Pure Gold?
I would have to look at the report to see, or my report to see. I don't remember.
Okay.
I want to say it was maybe fall of 24.
Okay. Well, do you think that reviewing that portion of your report would help refresh your recollection?
Absolutely.
And, Your Honor, I apologize. It's going to take me a second to find that particular one. Judge, my computer's frozen, so it may take a few more seconds. Judge, I'm going to show Mr. Cruz a report dated from September 5th of 2024. By Agent Bigham, sorry. Agent Bigham, I'm going to hand you a laptop that has a copy of your report from Thursday, September 5th of 2024. I'd like you to review it, don't read from it, and let me know when you've had a chance to review it.
Okay.
me know when it is that y'all sent the information to Pure Gold.
September 5th of 2024 is when I would have mailed it to Pure Gold.
Okay. Now, I want to go backwards a little bit and go back to May. Did you re-interview Mr. Chris Melton in May of 2024?
Yes, Agent Howell and I did.
Do you recall what date you re-interviewed him?
I believe it was on Sunday, May 5th. I believe that was the 5th.
Okay.
No, it was a Sunday morning for sure.
And just so we have our timeline, when was it again that Mr. Faust was arrested?
May 9th.
Okay. So going back to May 5th of 2024, that's obviously before the September date we just talked about. Is that right?
Yes.
Okay. So when you went to go meet with Mr. Melton and interview him, where did you believe his DNA had been recovered from?
At that point, we believed that it had been recovered from oral swabs, which would have been taken from Ms. Baker's mouth during autopsy.
All right. And I was not precise in some of my questioning. I've been saying, when did you re-interview him? Had y'all ever interviewed, and when I say y'all, I mean you, Agent Bigham, and Agent Howell, had the two of you ever interviewed Mr. Melton?
No.
Okay.
Had not.
Were you familiar with your review of the previous investigation in the case file, whether or not he had been interviewed before?
Yes.
Okay. Did you have an opportunity to review those interviews?
I did. I reviewed the audio recordings as well as the summaries that were written.
All right. And in your review of that, as well as your review of the case file, did you develop any kind of opinion about the way in which Mr. Melton perceived his interaction with law enforcement from the time period of the original investigation in 2001 and kind of continuing forward?
I guess my perception was that, I mean, obviously he was kind of the first suspect, the first person they looked at, and they continually looked at him for years. Interviewed, I believe, 4 times over the years by different people, different agents, different officers. And our perception was that, you know, he was the one that they were kind of continuing to go back to and ensure that they were getting statements from him and, you know, verifying his alibi and things like that.
Given that he had already talked to law enforcement several times, well, let me back up a little bit and lay a little groundwork. As an investigator who interviews suspects, are there certain interview techniques that you use?
Yes. I think it depends on the type of case, the type of person you're talking to, and kind of what you're trying to glean from the interview.
Okay. Was there any kind of technique or approach, even, technique might be a bad word, that you were intending to use or used with Mr. Melton on that May 5th interview?
As far as that's concerned, I generally do interviews pretty much the same way all the time. They're very relaxed, very casual. It's more like a conversation. I don't get fired up. I'm not a yeller that I can think of in any interview I've been in the past 18, 19 years. So I generally approach interviews like that. I kind of have this rule of thumb that I'm not ugly to anyone unless they give me a reason to be ugly. So with him, it was just very relaxed. I mean, obviously, we wanted to talk to him. We wanted to kind of rehash his story and go through everything again. But other than that, I mean, there was no reason to confront him or no reason to be ugly towards him.
And, you know, this might be a hard question, but if you know approximately how many of the original witnesses were re-interviewed as part of y'all's investigation?
Oh my gosh. I mean, I don't know how many were re-interviewed. I would say maybe 20 or 30 off the top of my head.
Okay.
We did well into 100 interviews, I would say, but as far as re-interviews, maybe 20 or 30. I'd have to go look
Okay.
for an exact number.
And I don't want you to get into any of the contents of the interview at this point, but after you arrested Mr. Faust on May 9th of 2024, did you and Agent Howell interview him?
We did.
Okay. And did Mr. Faust provide y'all with a statement at that time?
He did.
Okay. Agent Bigham, I'm going to show Mr. Cruz State's Exhibit 158. After that, I'll bring it up to you. What's that? Mark the State's Exhibit 158. Do you recognize that?
I do.
Okay. And let me ask you this. How do you recognize it?
So it's got a GBI evidence property tag number on it. It's got our evidence label on it. And I recognize the crime lab number that's on it as being this case's crime lab number.
All right. And do you know what is contained in that envelope or baggie?
I do.
Okay. And what is it?
It's, I'm assuming a box, yes, buccal swabs that were taken from the mouth of Mr. Faust.
Okay. And so when you say Mr. Faust, were you present when those samples were collected?
I was. It was Agent Howell and myself.
All right. Did you collect them or did Agent Howell collect them?
No, Agent Howell did.
Okay. But you were present when it was collected, is that right?
Yes.
Okay. And were you present when it was placed in that evidence bag?
I remember him boxing them up. I don't recall if he put them in a bag where we were right then.
Okay.
But boxing them up, they go inside of like a white cardboard box.
All right. And when you say Mr. Faust, do you mind pointing to the individual who you saw those buccal swabs taken from and describing an article of clothing that that person is wearing if they are present in the courtroom today?
Sure. So he is sitting over at the table over there by the door, and he's wearing an Argyle sweater that's light blue, teal, and gray.
And, Your Honor, I'd ask the record reflect that Agent Bigham has identified Mr. Faust.
It so reflects.
All right. And I'm not going to tender this exhibit through Agent Bigham. Your Honor, we'll connect up the rest of it with Agent Howell. If I could have just a moment, Judge.
Okay.
Your Honor, I don't have any other questions for Agent Bigham at this time.
All right. Mr. Cruz, cross-examination.
Good afternoon, Agent Howell.
Bigham.
Excuse me. Good afternoon, Agent Bigham. Please forgive me. You have opportunity to sit in the courtroom during the entirety of this trial. Is that correct?
Yes, it is.
And you've had the opportunity to hear everyone's testimony.
Yes.
You've had the opportunity to hear my opening. Is that right?
Yes.
The state's opening.
Yes.
Mr. Melton testify.
Yes.
Ashley P.B. Hall testify, as well as Valerie Lowe.
Yes.
On Sunday, May 6, 2024, you and Mr. Howell interviewed Chris Melton. Is that right?
I believe it was Sunday, May 5th.
Thank you for that. So Sunday, May 5th, you interviewed Mr. Howell. Excuse me, I am
Interviewed
sorry.
Mr. Melton.
Mr. Melton, please forgive me. And you met with him at the Walton County Sheriff's Office. Is that correct?
Yes, it was one of their satellite precincts.
And you knew during the interview, Chris volunteered that the longest he had gone without seeing Tara before her death, it was 10 days because of work. Is that right?
That's what he indicated initially in the interview before we helped refresh his recollection based on his original statements that were given immediately after the homicide.
And you asked him whether Tara slept at his parents' house the Saturday before her death. Is that correct?
I believe I did.
And Chris told you for a second time, no, I hadn't seen her for like 10 days beforehand or something.
Yes, we went back and forth through the 10 days and the 5 days and what was originally stated and whatnot.
Sure. And during your conversation, you told Chris, I don't have it on this, but I think what you said is that she slept at your parents' house a Saturday night before, and then she left Sunday morning, and that was the last time you saw her. Do you recall making that statement to Mr. Melton?
I don't recall that specifically. I'm not sure what the I don't have it on this is.
Can you repeat that for me?
I don't recall specifically making that statement. I can reference my summary if you'd like, but I don't understand the part where you said I don't have it on this. I'm not sure what I was referencing during the interview.
Sure, and I'll simplify the question. You recall telling Chris that he previously said that Ms. Baker slept at his parents' house the Saturday before her death.
Can I reference my summary?
Of course.
To clarify that?
Of course.
So I have that. I referenced the original interviews with him and that he told law enforcement back then that he last saw Ms. Baker the Sunday prior to her death.
Can you repeat that?
I referenced my notes that I must have written myself some notes that I had back then during that interview, and I relayed to him that he told law enforcement that he last saw Ms. Baker the Sunday prior to her death. And I do believe, yes, that was at the parents' house, his parents' house.
And Mr. Melton's response to you was, that doesn't sound right either. Is that correct?
I don't recall if that was his specific response, but he kept going back to the 10 days. He kept thinking in his head it was 10 days.
Multiple times, is that correct?
Yes.
And can we agree that Mr. Melton told you at least 3 times that the last time he saw Ms. Baker was 10 days before her death?
I don't remember how many times he said it, but I do know we had multiple conversations about it.
Sure. Would hearing your audio recording refresh your recollection?
Sure.
Court's indulgence? Let the record reflect that I'm going to refresh Agent Bigham's recollection from minute mark 14:57. Excuse me, 1 hour, 14 minutes, 57 seconds through 1 hour, 17 minutes, and 6 seconds. Just to make sure it's clear, what we're looking for here is Mr. Melton telling you 3 times that he hadn't seen Ms. Baker for 10 days prior to her death. Is that fair?
Yes. Do you want me to move this? Okay.
So you'd agree within that timestamp that was previously stated, you have heard Mr. Melton state at least once that he hadn't seen Ms. Baker for 10 days?
Yes.
Okay. And we've heard a second time that Mr. Melton puts the last time he's seen Ms. Baker at least 10 days before her death.
Yes, he states it's the weekend before.
The weekend before her death.
Before, yes.
Okay. All right, and within that 2-minute and 8-second time span, Mr. Melton has said at least 3 times that he has seen Ms. Baker for the last time 10 days prior to her death.
Yes.
And for the third time, you told Chris that you last saw her Sunday morning when she left. Do you recall making that statement?
Yes, based on the previous interviews.
Okay. But you're reminding him that previously he stated that he saw Tara the weekend before her death. Is that right?
Yes, we were refreshing his recollection.
Okay. And Mr. Melton told you a fourth time that it had been 10 days since he last saw Ms. Baker. Is that correct?
I don't recall if he said it a fourth time.
Let the record reflect that I'm refreshing Agent Bigham's Would hearing the recording refresh your recollection? Yes. Okay, so we're going to do number 4 and 5, okay?
Okay.
So let the record reflect that I am playing minute mark 1 hour, 20 minutes, and 10 seconds to 1 hour, 21 minutes, and 57 seconds, Your Honor. Okay, you've heard for a 4th time Mr. Melton state that he believes it was the weekend before her death. Is that correct?
Yes.
So he told you at this point at least 5 times that he had not seen Miss Baker for 10 days prior to her death.
Yes.
And this is after you've told him multiple times, or repeated to him multiple times, what he told law enforcement in 2001. Is that right?
Yes. I think he was processing, we were kind of going back and forth, like he was processing, you know, what he recalled and the fact that it's 24 years later at that point. So.
You then asked Chris, and I believe this is the 5th time you asked Chris, so was there ever a time in those 10 days, whatever, leading up until her death that y'all just had a quick booty call or met up real fast or anything like that? Do you recall asking that question? And for the 6th time, Mr. Melton stated that he had not seen Miss Baker within 10 days of her death.
Said that he had not been with her, I believe, the week of her death.
Mr. Melton's response was not no.
I don't recall specifically, but I remember the further we got into it, I recalled that he was saying, because we were going down the path of, did you see her at any point for a booty call the week of her death? We were trying to figure out and narrow that timeline, and he said no.
Let me make sure I'm clear on my question. The question that you asked him was there any time within that 10-day window that he met up with Miss Baker for a booty call? Would you agree on that?
I don't remember saying the 10 days. If I did, that's fine.
Sure. Would hearing the recording refresh your recollection?
Yes, I did state that it was in the 10 days. Had y'all had a booty call or met up real quick or anything like that?
And he said no.
And he said no.
Okay, so now we're at time number 6 that Chris Melton has told you that he has not seen Miss Baker 10 days within her death. Is that correct?
That's correct.
Okay. Now, you would agree that you told Chris that you know that he's been dishonest with police for 23 years.
I don't remember telling Chris he had lied to police for 23 years.
Do you recall telling Chris, I need you to be 150% honest with me?
Yes.
Okay. And you explained, I know that what I'm about to ask you is not what has been said for 23 years, and that may hinder you from wanting to be honest with me. Do you recall making that statement?
Something along those lines, yes.
And you then told Chris, but we're here because there's been some evidence that's come up that you can't really argue and say, I was with her 10 days prior. Do you recall making that statement?
Yes, something along those lines.
And then you shared with Chris, there's been some DNA that's come back to you. Is that fair?
Yes.
And this was before you told him. So what that leads us to believe is that perhaps you were with her at some point sexually, much closer to her death, and this is the language I emphasize, than has ever been let on. Do you recall making that statement?
Not specifically, but I do remember having that conversation with him.
Would hearing the recording of your statement refresh your recollection?
Sure.
I asked that question just to make sure the record is clear. So you told Mr. Melton, so what that leads us to believe is that perhaps you were with her at some point sexually, much closer to her death, and I emphasize this language, than has ever been let on. Is that correct?
Yes.
And at the time of the interview, you received a DNA report on May 2nd, 2024. Is that correct?
I did.
Okay, and the interview with Mr. Melton was May 5th, 2024. Is that right?
Yes.
And the reason you knew Mr. Melton's DNA was present in her mouth is from the May 2nd, 2024 DNA report. Is that correct?
Between the April 30th and the May 2nd reports, the swabs that the DNA had come back to were labeled oral. So that's what we believed at that point.
Sure. But the report from May 2nd also stated that Mr. Melton's DNA was present in Ms. Baker's anus as well. Is that right?
Yes.
Okay. And you were aware, as the lead investigator in this case, that Ms. Baker had been sexually assaulted. Is that fair?
Yes.
And you would agree that DNA lasts in the mouth for up to 12 hours. Is that correct?
I can't speak to that. I'm not a scientist. I have an understanding in what I was told, generally what can occur, but I can't speak to specifics about how long DNA lasts in someone's
Sure.
mouth.
But you told Mr. Melton that it lasts for 2 to 3 days. Is that right?
I don't remember specifically what I told him. I'm not arguing with you about it. I just don't remember specifically what I told him. But I do know that we had some information about how long it could last.
But we know it wasn't 10 days. Is that
Correct. That was not the information we had at the time. We did get information later.
And we could also agree that DNA doesn't last in the mouth 5 days.
I'm not going to speculate to that. I'm not a scientist. I don't know.
That's fair. But we did know Mr. Melton's DNA was in her mouth.
No. Mr. Faust's DNA was in her mouth.
Okay, so
ultimately.
is your testimony here?
You're talking about at that point?
Correct.
Oh, at that point, we believe that we knew it was on the oral swabs or a pack of swabs that was labeled oral at that time. And yes, that's what we believed at that point.
Fair. And you had access to the GBI's DNA experts. Is that right?
Yes.
So they could tell you, hey, either this should be here or this should not be here. Is that correct?
As far as what?
How long DNA lasts?
Yes, generally.
Now, despite this, you assured Chris, Jeremy and I are not here because we think you killed Tara at all. Is that a fair statement?
Absolutely.
And you tell Chris that his DNA was in a place that makes sense for you two, but doesn't make sense for bad guy.
Yes, because he was her boyfriend.
And bad guy is Mr. Faust.
That's who was identified through the CODIS match.
And Just to make sure, you didn't know Miss Baker, is that correct?
No.
And you tell Chris, we have bad guys evidence there, but we got to separate those two. Do you recall making that statement?
Something along those lines, yes.
And it is fair to say, despite acknowledging that Chris lied for 23 years, you were asking Chris to help you explain away his DNA to pin Miss Baker's death on Mr. Faust.
I don't believe that Chris lied for 23 years. I reviewed his statements that were given the day of Tara's death or murder, and 2 days later, and those statements were consistent and made more sense, especially with the new evidence that they had sex 5 days or so prior to her death.
Sure. So my question is this. If you don't think he was being dishonest, why would you make the statement so that leads us to believe that you were with her at some point sexually much closer to her death than ever has been let on?
Because when we were interviewing Mr. Melton, we obviously had this new information from the crime lab, and we're under the impression that it shouldn't last more than a few days or somewhere in that vicinity. At that point, we kind of were going with the information we had on that day at that point. Of course, that can change once evidence is processed and more things are done to it.
Objection narrative, Your Honor.
Overruled.
So we were going with what we had at that moment, and now I've totally forgotten your question. I'm so sorry.
Sure.
Can you repeat it?
My question was that you told Mr. Melton that, court's indulgence. I want to make sure I give you the proper question. But you told Mr. Melton that that DNA evidence led you all to believe that he had been with Miss Baker some point sexually, much closer to her death than has ever been let on. Is that right?
That's right. Thank you. So at that point, we're going with the information that we had in the moment from the crime lab reports, speaking with the crime lab personnel, etc. And we were re-interviewing Mr. Melton to obviously just go over the statement and go through all the things again, but also to ensure that there was nothing we were missing. Is there some reason that, he did have a booty call or go meet her for a quick, quick meetup or anything like that had just never come out before? And we were trying to explain why, or this evidence and why it was there. I mean, obviously we knew that's her boyfriend. It should be there, but we were trying to get the timeline down.
At this point, we agree that you had Mr. Melton's DNA in Miss Baker's mouth and her anus. Is that fair?
Are you speaking of that day?
Correct.
At that moment, that was the information we believed because both of the packages were labeled oral.
And during your interview on May 5th with Mr. Melton, with Mr. Melton told you that him and Tara did not engage in anal sex. Is that correct?
That's true.
And we also had Mr. Faust's DNA in her mouth. Is that right?
That's true.
So at this point, we can agree that the evidence against Mr. Faust at this time that you have is DNA in Miss Baker's mouth.
No, at the time, they had processed the other set of oral swabs, and that came back with Mr. Faust as well.
So my question is, the evidence that you had against Mr. Faust is DNA in Miss Baker's mouth. Is that right?
At that moment.
And at that same moment, we had Mr. Melton's DNA in her mouth. Is that right?
Yes.
DNA in her anus. Is that right?
Yes.
And also a statement from Mr. Melton that him and Miss Baker did not engage in anal sex. Is that right?
That's right.
And just for the purposes of this, Mr. Melton was not arrested at his May 5th interview. Is that right?
No.
Okay. You did not obtain warrants from Mr. Melton based on this information. Is that correct?
No, we would have no reason to.
But you explicitly told, or would you agree that you explicitly told Mr. Melton, well, I think Jeremy would agree with this. I don't want to speak for him, but like we are here to try to separate you from the killer. Is that fair?
Probably something along those lines.
Okay. And you were speaking again of Mr. Faust.
At that point, that was the other information we had.
Okay, based solely on his DNA in her mouth.
No, at that point, I mean, that was, what, 5 days or so? And we had already been working on and reviewing the investigation again. We had Mr. Faust's name 5 days prior to the interview with Mr. Melton.
Let me ask you this, because it's not a trick question. I'm not trying to trip you up or anything. When we're talking about physical evidence, the only physical evidence you had connecting Mr. Faust with Ms. Baker is Mr. Faust's DNA in Ms. Baker's mouth.
Yes.
But on this May 5th interview, although we have more physical evidence involving Mr. Melton, you tell Mr. Melton you want to separate him from Mr. Faust. Fair?
Right.
We've agreed on that.
Mr. Melton had an alibi.
You then asked Mr. Melton for the 6th time, so was there ever an instance closer to her death that you just went over and got a blowjob, that y'all met up real quick, you know, just get a little quick rump out? Do you recall making that statement? Okay, and before he answers, you tell him because 10 days before, there's not still going to be sperm. Like literally scientifically, it doesn't last in your mouth. Is that correct?
Sure, I said something like that.
Okay. So at this point, you aren't even interviewing Mr. Melton as a suspect. Is that fair?
No, he wasn't being interviewed as a suspect because he's had an alibi for 20-something years.
And you also made clear to Mr. Melton, but we have to separate you from the bad thing that happened and make sense of the thing that would be understandable and normal. Is that correct?
Something along those lines.
So can you explain to me how Mr. Faust's DNA being in Ms. Baker's mouth and Mr. Melton's DNA being in Ms. Baker's mouth and anus, although Mr. Melton stated they don't engage in anal sex, makes it understandable and normal? Can you explain that?
My understanding through speaking with the crime lab is that there's something called drainage and gravity. I mean, we all know what gravity is, but drainage, and that you can, that semen or sperm can drain down from the vagina to the anus, and that can be a possible way that it gets into an anus. And yes, while at that point, we still had 2 packs of oral swabs, we knew or had a belief that one of those was vaginal swabs. We just didn't know which one it was yet.
Let's talk about drainage. So we've established, at best, Mr. Melton says it's been 5 days before since him and Ms. Baker had sex. Is that fair?
Yes.
And we would assume, I know you say that you don't know Ms. Baker, but Ms. Baker would take a bath every day. Is that right?
I don't know specifically, but my understanding from previous interviews is that she would shower in the mornings.
Okay, and that's daily, right?
I believe so.
Okay. So your position is, and correct me if I say it wrong, we know Ms. Baker was sexually assaulted anally. Is that right?
Yes.
We can agree that in the May 2nd, 2024 report, Mr. Melton's DNA profile is the only identifiable profile. Is that correct?
In the May 2nd report?
Correct.
No.
I would like you to look at the 5th paragraph on the first page of the May 2nd report from Dr. Ashley Hinkle, please.
I don't have it.
I have it for you.
I have notes regarding it, if that's...
And I can give you the whole thing, or I can give you the pertinent page. Which one do you prefer?
What? Either way.
I give you the whole thing.
Okay.
Your Honor, I'm going to object. My understanding, Ms. Cruz hasn't said anything about refreshing recollection or anything along those lines. And it seems that he's asking Agent Bigham to testify off a report that she did not create. So I'm going to object.
But on direct examination, Agent Bigham testified that she was aware of the DNA report from May 2nd, 2024. So she's already established her knowledge of same. I asked her if she was aware that Mr. Melton's DNA was the only identifiable DNA in Ms. Baker's anus, and her answer was, I believe, no, I do not recall that.
Oh, I don't...
Okay.
Correct me. Please correct me if I make a mistake.
Was that your answer?
Well, I'm sorry. I may have misunderstood you. I don't remember you specifying her anus. I thought you were talking in general about the DNA. But if you're specifically talking about the rectal swabs, then yes, you're absolutely right.
I'm going to let you re-ask. Let's do this, since there's been an objection, but I think maybe this witness was confused by your question.
Sure.
If you'd like to ask the question again, you may do so.
Yes, ma'am. Mr. Melton's DNA profile was the only identifiable DNA profile in Ms. Baker's anus.
Yes.
Okay. In the state's theory and law enforcement's theory of how he's the only DNA profile is that it was drainage.
That was a theory that was proposed to me,
Okay, that's a theory,
or just a way that it can happen.
a way to explain away Mr. Melton's DNA so you could focus on this. Is that right?
No, I don't think that's accurate.
The form of the question, that's argumentative.
I'm going to sustain that objection.
Yes, ma'am. And you also told Chris that in order to separate him from Ms. Baker's murder, we got to figure out that timeline and clarify it, or it doesn't make any sense. Do you recall making that statement?
Something along those lines.
And you would agree that to a reasonable person, it could appear that you're asking for Chris Melton's help in pinning Ms. Baker's murder on Mr. Faust. Is that fair?
Object, Your Honor, calls for speculation.
I'm going to sustain that objection. I don't think it's a proper question. You may rephrase, Mr. Cruz.
Yes, ma'am. What you're trying to do, is it fair to say that you're trying to explain away why Mr. Melton's DNA was in Ms. Baker's mouth? Is that fair?
No, I'm trying to get an understanding of why it was in her mouth, because that's what we thought at that time.
Okay, so let me ask you this. We've already agreed, you and I are aware, that Mr. Melton was aware that Ms. Baker was sexually assaulted. Is that right?
I'm sorry, say that again?
Sure. We both are aware that Ms. Baker was sexually assaulted. Is that correct? Yes. You didn't find it odd when you told Mr. Melton about DNA in Ms. Baker's body. His response was, I'm taking in that there was something else in her, somebody else's stuff there too.
Mr. Melton, during that time, once we started getting into the specifics of the evidence that we had and what the questions we were asking him, he was starting to become kind of very distraught and almost just kind of like in shock. I remember talking about that with him, like, I was in shock as much as you're in shock. You know, like, he was trying to process everything, and I took that sort of statement as him sort of processing everything that we were talking about.
Sure. And that's your interpretation of his statement. Is that
That's
fair?
my interpretation.
Okay. But after you made that after Mr. Melton made that statement, Chris tells you for a seventh time, like, as far as, you know, the 10 days is stuck in my head. Is that correct?
Again, I think at that point he's sort of reeling and processing everything and trying to kind of make sense of this information that he's now learned after 20-something years.
Agent Bigham, this is your investigation. Is that correct?
Myself and Agent Howell?
Okay, but you are the lead investigator. Is that correct?
Sure.
And because of your work, this prosecution was brought against Mr. Faust. Is that correct?
Because of our work.
Sure. But you wouldn't want to do anything that would hurt your chances of convicting Mr. Faust. Is that right?
I just want to work a case to its proper conclusion and convict the right person.
Well, sure. And that's an excellent point. When we talk about convicting the right person, you would agree that when you obtained arrest warrants for Mr. Faust, the only evidence you had of his connection with Ms. Baker was DNA in Ms. Baker's mouth. Is that fair?
Yes, that was the only evidence we had of their connection.
Okay.
They had no other reason to be connected.
Sure, but physical evidence, just DNA in the mouth.
That's correct.
Okay. But for Chris Melton,
I apologize. At the time of arrest?
physical evidence, correct.
Yes, yes.
But for Chris Melton, we've already established that we have DNA mouth, DNA anus, and a statement from Mr. Melton saying that they did not engage in anal sex. Is that right?
That's accurate.
But based on your determination, the right person to arrest is simply the person whose DNA is in her mouth.
It was Mr. Faust.
And Mr. Melton.
No, I'm talking, you said the right person to arrest, and I said
Sure.
Mr. Faust.
But, and Mr. Melton, because Mr. Melton's DNA was in her mouth as well. Is that right?
It was, but Mr. Melton had an alibi.
And you would agree that you told Mr. Melton you were shocked to learn that his DNA was present.
Yes, I believe I said something along those lines.
Okay, and you explained to him, and in my thought, when I got this news, and I was about as shocked as you are right now, last week, you were a 23-year-old kid. You were being hammered by the effing cops that are treating you like S, you know, after you've just found out your girlfriend's been brutally murdered. Is that correct?
Yes, I remember making those statements.
And then you continued. You stated, and you're terrified knowing, yeah, y'all had a booty call. You know, she got back from the library that night. You came up. She went down to have a booty call real quick. And you know, in your head, you're like, I was literally the last person with her.
That was an interview tactic, I guess, or technique, whatever you want to call it, that I was using to just try to give him one more opportunity to let us know if something had occurred that week. Like, just basically putting into context for him, like, you were a kid and, you know, you were scared and the cops were going after you and things of that nature, and just trying to give him an out to give us that information. But he stuck strong to his statements that he was not with her that week at all.
And he also stuck strong to his statements that he hadn't seen her in 10 days as well. Is that correct?
By the end of the interview, we had come around, and he agreed that with the prior information or information from his prior recordings that I had listened to, that he agreed that it was accurate, that he had had sex with her, or they may have had sex on that Sunday before she left his residence, which would have been in that 5-day marker.
Yeah, and I would ask for the opportunity to get my answer from the witness, because we are on cross. Excluding the narrative, another report said that the witnesses are allowed to narrate after they answer a question.
No, they're allowed to explain, Mr. Cruz. So tell me what your objection is. Do you have an objection?
I'll make the objection when it takes place, Your Honor. I think that's the appropriate way to handle it.
All right, go ahead, sir.
But then you told Chris, you know you didn't kill her, but you were the last person there before she got killed. Do you remember making that statement?
No, I mean, I do remember making that statement, but that was in the context of me giving him that narrative of the last, or giving him an out with that narrative. That was not separate, nor was I telling him he was the last person with her. It was in the context
Objection,
of that narrative.
Your Honor.
I'm going to overrule that. I think she's explaining her answer to you, Mr. Cruz. I'm going to overrule that objection.
And you continued, and so in my mind, it makes complete sense that you would be omitted from the conversation because you don't want any more pressure on you. They are already hounding you enough, and you know that you didn't kill her, but you knew you were with her. You would agree that's an accurate statement?
No, that was my narrative that I was giving to him to use as a technique to try to give him one last opportunity to tell me that he was with her, if that was the case. But again, it was not.
Well, this is an interesting thing. You've already told us that when you interviewed Mr. Melton, you weren't interviewing him as a suspect. You were just interviewing him to have a conversation with him. Is that right?
Yeah, that's right.
So giving him a justification as to why his DNA was present when it should not have been, would it be fair to say that you were justifying or trying to explain away his DNA with him?
No, I mean, his DNA should have been present. He was her boyfriend at the time.
Sure. And
I wasn't giving him a justification. I was ensuring that we...
Objection, narrative, Your Honor.
I'm going to overrule that objection. You've asked a question. She's answering your question. I'll allow her to answer.
I was ensuring that we... trying to think of a good word to use. I was ensuring that we clarified everything in his statement and interviewed him in the best way possible before we started kind of moving on to Mr. Faust. And obviously we knew going in that he had an alibi and he did not kill her, but we were trying to do our best to explain this DNA with what we had at that moment.
And despite you explaining or giving him a way out, Chris still doesn't change his timeline from 10 days. Is that correct?
No, I believe I already stated that towards the end of the interview, he agreed that they would have had sex on that Sunday before she left his parents.
Let me specify the question. After you told Chris you know you didn't kill her, but you were the last person there before she got killed, and so in my mind, it makes complete sense that you would be omitted from the conversation because you don't want any more pressure on you. They are already hounding you enough, and you know you didn't kill her, but you knew you were with her. Chris's response was, "That's the tough part. Like, I don't recall being with her between the time."
I would have to listen to it, but I mean, we don't have to. I'm just saying that again is the narrative that I was kind of spewing to him to see if he was going to say anything else before we concluded this interview.
So my particular question,
But no, I don't believe it was accurate.
my particular question is, after you made that statement to Chris Melton, he still did not change his timeline from 10 days.
He was still kind of reeling all the information and kind of, he was almost like having a conversation with himself.
Objection,
out loud.
non-responsive.
Overruled. You've asked her a question, and she's answering it. I'm going to allow this witness to answer your question. Agent Bingham.
I'm done.
Is that a yes or a no, Agent Bigham?
You'll have to ask me your question.
Sure. After you gave him the statement about him not being the killer, and specifically, you know you didn't kill her, but you knew you were with her, Chris still did not change his timeline from 10 days. Is that correct?
I don't believe that's accurate.
And you've heard portions of this interview. Is that correct?
Yes.
Okay. And you recognize the interview because it's your interview with Mr. Chris Melton. Is that correct?
Yes.
Based on the portions you heard, had that interview been altered in any way?
I only heard minutes of it.
Sure.
I would assume not, but I can't speak to that.
So I'll let you hear minute mark 1:28:16 to 1:28:43.
Yeah, he said.
But that is a fair and accurate portion of your statement or your conversation with Mr. Melton on May 5th, 2024.
Yes, a portion of my conversation.
Okay. And for that particular portion, which is minute marks 1:28:16 to 1:28:43, you recognize that particular portion. Is that right?
Yes, I do.
Okay, and it hadn't been altered in any way to your knowledge.
I don't believe so.
Your Honor, I would move to introduce minute mark. Well, excuse me. Let me show the state. Please forgive me.
All right.
I don't have any objection, Judge.
All right. And what is, there's no objection, but you, Mr. Cruz, tell me what you want to admit.
Sure.
All right.
As Defense Exhibit 47, I am admitting minute mark 1:28:16 through 1:28:43
Right.
of Miss Elizabeth Bigham's conversation with Mr. Chris Melton on May 5th, 2024.
It is admitted.
And may I publish? Same
May.
procedure, Your Honor.
and you in your head like I was killed. You were the last person there before she got killed. And so in my mind, it makes complete sense that that would be omitted from the conversation because you don't want any more pressure on you. They're already hounding you enough, and you know you didn't kill her, but you knew you were with her.
That's the tough part. Like, I don't recall being between the times. Like,
So again, Mr. Melton is telling you he does not recall being with her in between that time. Is that correct?
Right, and at that point, he's just reeling over all this information. He's visibly upset to the point where we got him tissues, and just kind of processing all this information. So we're going back and forth about it.
You said you two were going back and forth about it?
Like, that's what we had been doing, like, back and forth as far as, like, going, like, him talking about the 10 days, me talking about what he previously said, things not in an aggressive or argumentative way.
So it got to a point where Mr. Melton, as we've agreed, has stated multiple times that 10 days was the last time he saw Ms. Baker. Is that right?
Like I've said, I believe towards the end of the interview, we came to an agreement that they had sex Sunday before she left his parents' residence, which would have been the 5 days.
Sure. So my question is, during the interview, at some point, Mr. Melton continued to say that he hadn't seen Ms. Baker for 10 days. Is that right?
Yes, he said it multiple times.
And at a certain point, you would agree that you and Jeremy Howell started pressuring Chris to change his answer. Is that right?
No, we were just talking to him and trying to refresh his recollection and explain to him that what he said the day of her murder and 2 days, or I'm sorry, 2 days after her murder, I apologize, was that they had sex 5 days prior.
Okay. And you interviewed Mr. Faust. Is that correct?
Myself and Agent Howell did.
But Mr. Faust didn't get that same benefit, did he?
We didn't get that far in the interview.
Did Mr. Faust get that benefit, yes or no?
And Judge, I'm going to object. The interview is not in evidence, and the defendant is not allowed to elicit possible self-serving hearsay.
I didn't.
Response, Mr. Cruz.
Absolutely. This officer has personal knowledge of the interview as she was present, and I didn't ask for any hearsay statements, Your Honor. I just asked if Mr. Faust received that same benefit.
Okay, I think that Mr. Yelmanchili's statement is a correct interpretation of the law. I'm going to sustain the objection.
Yes, ma'am. But our last question was that you and Mr. Howell began pressuring Chris to change his timeline. Is that correct?
I don't know that I'd call it pressuring. We were, again, utilizing interview techniques to try to elicit information if it were any different than what he had been providing for 20-some-odd years.
Okay. Well, I asked you about that earlier, and you stated that you didn't believe Chris Melton lied 23 years earlier. But now you're saying that...
No, we didn't. We were trying to explain the DNA and trying to understand why it was there.
So would you agree that the statements that Mr. Melton had given for 23 years prior was inconsistent with the DNA you had in Ms. Baker's mouth?
That's hard to answer because at that moment, because we believed that that was her oral swab, that was the oral swab.
At that time, May 2nd, we're talking about May 2nd.
That's what I'm trying to think through. Can you ask me the question one more time? I apologize.
Sure. The statements that Mr. Melton had given for 23 years was inconsistent with the information you had regarding his DNA being in Ms. Baker's mouth.
Yes, I guess that would have been inconsistent at the time with the information we had in that moment.
Sure. But Chris has asked, despite this conversation and him saying 10 days, he has asked, is there even a percentage of a chance you were with her Thursday night? Is that correct?
I'm sure I said something like that.
Okay, and Chris responded no.
That's correct.
He was then asked, not even a 1% chance? Is that correct?
Yes,
Chris again responded no. Is that right?
that's correct.
And despite him saying no, he is then asked again, even Wednesday night. Is that correct?
That's correct.
And Chris responds no.
That's correct.
However, despite Chris saying no, law enforcement tells Chris, I understand you're saying you don't recall.
Are you saying we told him that?
Correct.
I don't remember.
You don't remember making the statement, excuse me, you don't remember Mr. Howell making the statement, I understand you're saying I don't recall?
I don't. I mean, I'm not arguing with you that he did make the statement, but I just don't remember that specifically.
I'll let you listen to the portion just to make sure it's accurate. Okay. Your Honor, may I approach the
You
witness?
may.
Do you recognize the recording, Agent Bigham?
I do. That's Agent Howell speaking.
Okay, but you're present as well, is that right? Okay.
Yes.
And did that recording sound like it had been altered in any way?
No.
Okay, and we've already established that this is the May 5th, 2024 interview with Mr. Chris Mellon.
It is.
Okay. Your Honor, I would move to admit minute marks 1:28:58 through 1:29:10 into the record.
Is this D48?
No, this is the same exhibit. I'm just marking different points that would be admissible, and I'll give the court reporter the portions that'll be admitted.
I think it's probably best we just call it 48.
D48. How will we sticker it?
I'm not exactly sure at this point, but just for the record, to be clear, these are two separate
Portions.
entries, and it can be the same thing. And just so it's recognized that they're two separate entries, the last one is 47, this is 48.
Yes, ma'am.
Is there any objection?
Yes, Judge. I took Mr. Cruz's original action to be refreshing the witness's recollection, which she stated she was refreshed and then testified consistently with the statement. So I don't know that there's any reason to admit it for publication in front of the jury as a prior inconsistent statement, which seems to be what Mr. Cruz is planning on doing here.
All right, Mr. Cruz, you care to
May I
respond?
respond? Sure.
Yeah, of course.
The question I asked her was just personally to make sure that she recognized that so I could lay the foundation for a prior inconsistent statement. Her statement to that question was, or to my last question that led to this, was in regards to despite Chris saying no, Chris was told, I understand you're saying I don't recall. And her response to that was no. So I laid the foundation as a prior inconsistent statement, and we're asking for admission as saying.
Okay. Mr. Yalmanchili?
That wasn't her response. Her response was, I don't recall, at which point Mr. Cruz played this statement for her, and then she responded, yes, that is Agent Howell. So,
I mean, I think that's accurate. I don't think we're dealing with the prior inconsistent statement. I'm going to sustain the objection.
Yes, ma'am. So, however, despite Chris saying no, he's told, I understand you're saying I don't recall.
No, when I listened to that just now, my understanding of what Agent Howell was saying was, I understand if you don't recall. That's how I interpreted what Agent Howell was saying.
Sure. Your Honor, I would ask to admit minute mark 1:28:58 through 1:29:10 as a prior inconsistent statement. Or
That's
it's
my
two,
interpretation.
impeachment by contradiction as well. So I think this one would fit more so under impeachment by contradiction.
All right. Mr. Yalmanchili, any response?
I just have the same response as I had before, Judge.
I think based on the witness's statement, Mr. Cruz, you have not proved that this is a prior inconsistent statement for purposes of admission. You may be able to admit it later, but for this specific purpose, I'm going to sustain the objection.
Okay. Is this sustained in regards to impeachment by contradiction as well?
Yes.
Okay. Understood, Your Honor. Now, during your questioning, you have no reason to disagree that Chris changed his timeline from 10 days to 5 days. Is that fair?
We talked about it towards the end of the conversation.
Okay. And with that conversation that you had with Chris, you told Chris, but I think what you said is, and I believe we talked about this, is that she slept at your parents' house the Saturday night before, and then she left Sunday morning, and that was the last time you saw her. Is that accurate?
Yes, that's accurate.
And Chris is then told that you and Jeremy have to be able to explain his DNA and that he needs to be within a certain window or you can't explain his DNA. Is that correct?
I'm not going to argue with you that it's not. I'm sure it is. But we were, again, trying to explain to him that we've got to understand why this DNA is in here
Okay. So
in a certain window.
did you have to explain it for Mr. Faust?
Again, we didn't get to that point.
Okay. Did you try to explain it for Mr. Faust?
We didn't get to that point in the interview.
I'm going to sustain that objection.
Thank you.
At the time you interviewed Mr. Faust, you already had a...
Again, Judge, he can't reference this interview without it being admitted, and as the defendant, he can't admit it.
Judge,
Mr. Cruz and Mr. Yalman-Chile, may I see you at the bench, please? Thank you. I think it's... Yes. Let me ask that question.
At the time of your interview with Mr. Faust, you had already secured arrest warrants. Is that correct?
Yes.
So in regards to Mr. Faust, we have DNA in Ms. Baker's mouth, and based on that, Mr. Faust, an arrest warrant is issued for Mr. Faust for murder. Is that correct?
Yes.
Okay. Felony murder. Is that correct?
Yes.
Burglary. Is that correct?
Yes.
Arson. Is that correct?
Yes.
Aggravated sodomy. Is that correct?
Yes.
Okay. But Mr. Melton's DNA is in Ms. Baker's anus, and an arrest warrant isn't issued for Mr. Melton for sodomy. Is that right? It isn't issued for murder?
No.
Despite acknowledging that Mr. Melton may have said something for the past 23 years that wasn't consistent with the DNA evidence that you had on May 5th, 2024.
Was that a question?
Yes, ma'am.
I'm sorry, you'll have to rephrase.
Sure. Now, let me ask you this way. Despite having Mr. Melton's DNA on May 5th, 2024, okay, and despite knowing his statements for the past 23 years were inconsistent with the DNA evidence that you believed you had on May 5th, 2024, an arrest warrant was not issued for him.
No.
Okay. Now, let me ask you this. Do you know Mr. Melton's family?
No.
Okay, so you don't know if he's related to anybody?
No.
Okay. Does he have any family in law enforcement that you would know of?
No idea.
So just based solely on Mr. Melton, I'm assuming being Mr. Melton, an arrest warrant isn't issued for his arrest.
Mr. Melton had an alibi that made it impossible for him to kill Tara Baker.
And you've been in the courtroom each and every time we've talked about Mr. Melton's alibi. Is that correct?
Yes, but I also reviewed it in the 20,000-plus page case file and multiple interviews over the years.
And you'd agree that once Mr. Melton is told that window we're in is we have to be able to explain why you are where you are just as much as we have to explain why someone else is there as well. But it's a narrow window, and it can get complicated if your window is greater than the window of expectation for how long evidence could be there. And that's what we're trying to drill down into. The further in time you are from how long this could last, the more complicated and less reasonable that explanation is. Do you remember Mr. Melton being told that?
Did I say that, or did Agent Howell say that?
Mr. Melton was told that.
I'm sure he was. I don't recall if I said that or if Agent Howell said that.
But once that statement was made, we can agree that Chris then says, if anything, it would have been maybe that Sunday the weekend before. Is that correct?
We had been talking about that the entire time because I had continually refreshed his recollection on the statement he gave 2 days after Tara's murder.
So, Ms. Bigham, my question is, after that statement was made to him about his DNA, his response was, if anything, it would have been maybe that Sunday the weekend before. We would have done something Sunday morning before she left. Is that accurate?
Yes, he did state something along those lines.
Now, Ms. Bigham, we've agreed that Chris Melton stated that Ms. Baker spent the night at his parents' house the weekend before her death. Is that right?
Yes.
Okay. However, you would agree that nowhere in your case file or in no report that Mr. Melton's parents ever confirmed that Ms. Baker stayed at their house the weekend before her death. Is that correct?
I do know they were interviewed. I don't believe they were asked about that, but I would have to look at the report to be certain, but I don't believe they were asked about her spending the night.
So the answer to my question is a yes. Is that correct?
Well, yes, they were interviewed.
So my question was that Mr. Melton's parents never confirmed the information that Ms. Baker was at their home the weekend before her death.
I believe that's correct.
And you cannot show the jury any report confirming Mr. Melton's claim that Ms. Baker was at Mr. Melton's home the weekend before her death.
No, I don't recall seeing anything there.
In fact, law enforcement simply took Chris's word for it. Is that correct?
I wouldn't say they took Chris's word. They conducted additional interviews with alibi witnesses, for lack of a better way of saying it.
Objection. Non-responsive, Your Honor. My question didn't involve alibi witnesses.
I'm going to overrule the objection. I think this witness is allowed to explain her answer. You may follow up with any questions.
Sure.
They conducted interviews with additional witnesses that could confirm where Chris was on Friday morning. Their focus was on Friday morning. That was law enforcement's focus back then.
This is your case file. Can you show the jury where that information is in your case file?
Where what information is?
That Mr. Melton or anybody confirmed that Ms. Baker was with Mr. Melton the Saturday before her death.
I never said that they confirmed that.
Okay, so that isn't confirmed. Is that right?
No, I never said that. I said that law enforcement focused on his whereabouts Friday morning of her murder.
So based on the information you had on May 5th, whether that window was 12 hours, a couple of days, you would agree at the time of Ms. Baker's death, Chris Melton's DNA being in her mouth would suggest that he had been dishonest about the last time he saw Ms. Baker.
We believed at the time of the interview that it was in her mouth. That was later determined to be incorrect based on additional crime laboratory testing that we did.
Let's talk about that because I believe you've mentioned that a couple of times. So I would like to hone in on that. And is it okay if we have a discussion about that?
Sure.
Okay. Now, we've agreed that you told Chris, or Chris was told, that law enforcement needed to be able to explain his DNA. Is that fair?
Yes.
Okay. And it is fair to say that Mr. Melton would not put himself with Ms. Baker within the week of her death. Is that fair?
That's correct.
Okay. You would agree that by removing Mr. Melton from her mouth and putting Mr. Melton in Ms. Baker's vagina, it changes the timing window. Is that correct?
My understanding is the window that sperm can last in the vagina is different than in the mouth.
Which would allow you to explain Chris's DNA. Is that right?
Once we determined that those were indeed vaginal swabs, it definitely made more sense.
Okay. You would agree that you did not obtain the result, well, excuse me, the testing that you did was with a California company. Is that right?
Yes, with
Okay.
Procedural.
And we're in Georgia. Fair?
Yes,
We're on the East Coast. Is that correct?
that is correct.
Pure Gold is on the West Coast. Is that right?
That's right.
And you heard Ms. Lycon's testimony?
I did.
And she stated that multiple labs throughout the United States conduct this type of testing. Is that fair?
I believe she said that.
Now, we could agree that we didn't move Chris from the mouth to the vagina until November 4th, 2024. Is that right?
Is that when the Pure Gold report was issued?
Unfortunately, I cannot answer
No.
any questions.
If that's when the Pure Gold report was issued, then that was when we got confirmation that those were vaginal swabs.
Would you have any reason to disagree that that report was issued November 4th, 2024?
I don't, but I would have to look at it to be 100% certain.
Now, you mentioned confirmation that it was vaginal swabs, but Ms. Lycon herself said this is a presumptive test. There is no confirmatory testing. Would you agree?
Yes, she did speak to that.
Okay. So, for the benefit of Mr. Melton, the mouth swab was turned into a vaginal swab based on a presumptive test. Is that fair?
I would say it was for the benefit of the investigation, not for Mr. Melton specifically. But we needed to figure out which ones were vaginal swabs because we knew from the vaginal smears that one of those packs had to have been vaginal swabs and they were just mislabeled.
Well, this is the thing. You would agree there have been a lot of mistakes in this investigation, right?
I'm not going to speak to other potential mistakes.
Well, you've been in the courtroom with us. We had an incident. You remember the incident where we opened the package, the state admitted, and it was empty, but it was supposed to contain hairs. Do you recall that?
That was the package that the hairs were collected in. Once the hairs go to the crime lab, they get mounted on slides.
Sure. How about the clock? Did you hear the testimony about the clock being lost?
I don't remember the clock being lost.
That's fine. How about the screen? Did you hear the testimony about the screen being lost?
Oh, absolutely.
Do you all have possession of Miss Baker's house keys?
I don't believe so.
So Miss
As
Baker's...
far as the GBI is concerned,
Correct.
I don't believe so. And I don't remember seeing them during the evidence inventory.
So Miss Baker's... Let me make sure. You're saying that you never had a set of keys from Miss Baker?
I don't believe so. I don't recall seeing a set of keys
From Miss Baker, is that correct?
from Ms. Baker.
Court's indulgence, Your Honor.
I can look through the evidence list if you'd like me to.
Please do, and I'll look through the one that we have as well.
Are you speaking of Elvis key ring with 2 keys, Tara's apartment?
I am.
Oh, I mean, it says yeah, we did check it actually. I just don't remember.
So do you have possession of Miss Baker's keys?
No, I do not have possession.
Okay, where are Miss Baker's house keys?
I don't know. They were in the possession of the Athens Clark County Police Department on December 11th of 2023.
As
I apologize. I don't remember. There were 180-something pieces of evidence that we inventoried.
Do you have the lock to Miss Baker's home?
I mean, I don't believe we have everything. I think Athens Clark County Police Department has all of the evidence. I do recall the lock. Yes, the deadbolt from the front door. Is that what you're speaking of? Yeah, that was inventoried and we checked it on December 11th.
Do you have possession of that lock in the courthouse here today?
I have no idea. I'd have to go look.
Do we have possession of those keys in the courthouse here today?
I have no idea. I'd have to go look.
All right, but you stated that you are the lead investigator on the case with Mr. Howell. Is that fair?
Yes.
Excellent. So I want to talk about the physical evidence from Ms. Baker's house based on your investigation and your decision to get an arrest warrant. We can agree that no hairs in the home were connected to Mr. Edrick Faust. Is that fair?
Yes.
Okay. If you could write under arrest warrant secured, no hairs. And we could also agree in regards to Mr. Melton's hair, his hair was found on the cord used to strangle Ms. Baker. Is that correct?
No, that's incorrect. It was found on the, I think people keep calling it the power transformer box for the printer. Now, the cord of the printer was utilized to do that, but if I'm not mistaken, it's on the power transformer box.
And that power transformer is connected to the cord that was used to strangle Ms. Baker. Is that correct?
Yes, that's my understanding.
As far as fingerprints, I'm sorry. Attorney Hill, if you were right, hair on, and make sure I put this right, Ms. Bigham. I want to make sure I get this accurate, okay? Put hair on, under Melton, correct. Under anal. Hair on weapon. Is that fair? Power cord was used as a weapon?
It's on the power transformer box. It was not on the cord.
That was connected to the cord, is that right?
Sure.
Okay, fingerprints. None of Mr. Faust's fingerprints were found in the house. We could agree on that.
That's correct.
Okay. And I won't go into the interview. I'll save that. But at this point, the evidence we do have, DNA, mouth, anus, Mr. Melton did not engage in anal sex. Mr. Melton, hair on power transformer connected to the cord used to strangle Ms. Baker. Is that fair?
Yes.
We also have a mitochondrial DNA test that states that the pubic hair found on Ms. Baker's butt could not eliminate Mr. Melton as the contributor. Is that correct? And that's from 2007, from lab court.
And you say that it couldn't eliminate Mr. Melton? I'd have to look at the report again to refresh my recollection.
Sure, and I believe it's already in evidence, so that's fine.
Okay.
But you did not have any hairs that was in your GBI or ACCPD's custody tested for DNA. Is that correct?
No, we did not.
Okay.
In 2024 or 3 and beyond.
Okay. You had the swabs and you solely went off the swabs. Is that correct?
No, after meeting with the crime lab that in February of 24, we went through every piece of evidence. The meeting was hours. We went through every single piece of evidence with each section head of each area. So hairs and fibers, DNA, latent prints, etc. And went through all the evidence and talked about all the evidence, what had been done on it in the past, what could be done on it in the future, or not in the future, but now. Had any technology changed or been updated that would be valuable to retest or to help retest these items. And that's how we determined what we could resubmit versus what couldn't be resubmitted because either maybe the technology wasn't there or nothing, they've already done everything with it and there's nothing else to do, things like that.
So can you tell the jury what items of Mr. Melton's were, well, let me rephrase that. What items were resubmitted for DNA testing? Because I understand that you all's position is the reason we have the DNA is because of new technology. Is that fair?
Yes, newer technology.
Okay.
That's my understanding.
Excellent. But we can agree that no DNA testing took place of the unidentified hairs. Is that fair?
Yes, but there was reasons for that. Some of them were not suitable didn't have a root suitable for DNA testing, et cetera. I have an explanation for some of the hairs.
Sure, that's fine. Now I'd like to ask you this, and I'll end on this note with you. And I won't go deep into it, but we've talked about the DNA in the mouth and anus. Is that fair?
Yes.
Okay, and we've already agreed that you were armed with that information. Is that correct?
Some of that information on
Okay.
May 2nd.
And despite being armed with this information, you told Chris Melton, but that's why it doesn't matter. If you're like, you know what, I effing lied about it 23 years ago because I was a scared, terrified kid. And you're right. I had a booty call with her that night. I left at midnight. I don't know what happened after that. It'll be, thank you, have a nice day. We'll let you know what happens. Laughs, like that's it. Is that a correct statement from you?
Yes, because Mr. Melton had an alibi that would have made it impossible for him to kill Tara.
And you explained to Chris again, we just want to be able to explain it and make it make sense so we can focus on this. Is that correct?
Yes.
Thank you. Those are my questions.
Any redirect to Mr. Yellow-Chili?
I don't have any redirect questions, Judge.
All right, you may step down.
Do you want this, or do you want me to leave it?
All right, ladies and gentlemen, it is 5 o'clock, perfect stopping time. We are going to stop the trial for today. I'm going to release you, ask you to return, of course, tomorrow at 9 o'clock. Please don't talk about the case, do any independent research, go to any of the places that you have heard about in this case. And of course, as I talked to you about yesterday, I know I keep repeating the same instructions, but it is important. Certainly try to avoid all social media that could show you some things about this case that were taken up outside your presence. That certainly would not be appropriate for any of you to see, which is why we do things, of course, outside your presence. I know sometimes it probably seems really difficult for you to get up and get down. I know I mentioned this yesterday, and I'm sorry about that. It is very important, however, to have certain proceedings outside your presence, and I appreciate your patience in all of that. With the thanks of the court, you're all excused for today. We'll see you tomorrow morning at 9 o'clock. Anything else, Mr. Yellow-Chili, Mr. Cruz, we need to take up before we release everybody for today?
Nothing from the state, Judge.
Mr. Cruz, anything, sir? No, ma'am. All right, thank you. I'm going to ask the media who are here who have our badges. We're going to let the bailiff collect them, so they'll return them to you all tomorrow. It'll help us kind of keep track of who is here. I appreciate your cooperation so much. Thank you. Thank you. Court is adjourned. We'll see you all tomorrow morning, 9 o'clock. Thank you.